Welcome, welcome, welcome. We are live. We're all the way live. We currently have 245 subscribers. Welcome to our channel. And welcome to this broadcast. If you're watching, thank you. Please share. We encourage people to share and click the notification button so that you receive notifications when we go live because this is a live broadcasting channel. We don't provide a lot of videos because this is a live streaming channel. Thank you and welcome. This is this particular broadcast is geared towards learning and gathering information concerning trust instruments, as well as understanding proper documentation, choosing an estate name, and so forth. It is essential that we understand the legal language used in documentation of these type of instruments, deeds, and trusts. Now, we're not specifically talking about a written deed. However, getting instruments in the name of the trust is within itself creating a deed document of title. Okay? And so, what we're doing is trying to understand what uh, it means when we see a name or title um, that reads, okay, for example, John Doe Trust in parenthesis, okay? And if you were to encounter a name of that kind, what does that mean? So, in your decision making, you also know if you choose to name your trust entity in this manner. What does it mean? And not just be copying off of, monkey see, monkey do, or some guru told you to write it this way, and you have no clue what it means. So we're learning the syntax, understanding of translating the legal implications of dealing with an entity that is titled in such a manner where after the name, at the end of the name, it has estate, the word estate in parentheses, okay? Or at the end of the name, it has the word trust in parentheses. And so, since an estate is not a trust and a trust is not an estate, okay, a trust can hold an estate, but a trust is not an estate. We want to understand the difference between the two thoroughly enough to get an understanding of what it is um, we are implicating when and if you choose to create a name, title, and in so how may you indicate that that name, title is a trust or a representative of the a title name is as representative of the estate, because the estate itself is not an actual person. Or no, I won't say person because it is conceived a legal person. Um, we want to indicate that it is not a natural person. That would be a way of doing so in writing to be understood. This is not a person, even though it appears to be a person's name. This is the title and identification of a fiduciary that is handling this estate, or the trustee that, or executor that's handling the trust. Okay, we're gonna go ahead and put on this display a video that will help us to get in the vein of understanding the how people encounter um, even being in a position where they need to create um, a name for the trust, and that is by if you're building an estate, bought a home, whatever the situation may be, you've earned enough money in your lifetime to have enough financial assets to be concerned with this type of matter. If you do not have an estate or have no intentions of building an estate or dealing with the trust, this would not be content of any interest to you in that regard. But however, it is important that if you're one of those type of people, you're around people who are discussing this matter or looking into handling their estate in a more, I would say, responsible manner, then, and you know that what I mean by handling their estate in a more responsible manner, some people do not even realize that once they purchase a home, that that is the beginning of building an estate. And so they have been irresponsible in drafting documents to isolate their assets as it established private estate. And so it kind of generically is considered as an estate in common law. Um, there are courts, probate courts, that handle generic estates. What I mean by generic is um, everybody is considered to have an estate until otherwise uh, proven not to be so. Okay? This is why we have a public trust. It has a public trust that's been drafted uh, to include that generic estate as implied. Uh, it's like it's just an assumption that you have an estate because you're a person, okay, and you have a state of being that has interests. That has equitable interest to you or someone else. Even when you file for your taxes, and you file and say, hey, I have dependents. These are the people that I am caring for uh, financially, okay? I am responsible for their well-being, okay, their estate. I'm responsible for their estate. When you list uh, an individual as a dependent. Okay? That means they're dependent on your estate as a parent. Okay? And this is what placing that word in parenthesis, parenthesis. It's a theory that everyone has a parent, someone or something that's over or responsible for that particular entity or person or whatever, property. And in that regard, the thesis is, the theory is that every individual is already placed in a possessory position of an estate. When you have already been documented, that's the reason why they have a problem with undocumented people. People undocumented. They don't have a problem with you being here legal. They have a problem with you being undocumented. It's a problem with being undocumented. Okay, so back to where we have we got some scammers interrupting. Who that company ain't nothing but scammers. Well, point. Anyway, we're proceeding on, and we're gonna. We all. Pardon me. I'm trying to get back to this video that I was reviewing, and she's discussing having or writing a written language of the use of parentheses as a hidden language within that, okay? That people who are grammatically inclined to know and understand the legal implications of how something is written and the importance of how it's written, the contractual liability and who is responsible for what, okay? Because in anything, everyone holds liability. Everyone holds liability to public trust. Public trust is established through implied liability. It's implied. Everybody is responsible for something. This is why everybody is required to have insurance. If you are a human being, then you have medical insurance to cover your person, you as a person, for the care of you as a person. If you as a human being malfunction, if you malfunction as a human being, as a person, considered by the state as an individual with capacity to contract, then you are the public trust is created for that purpose, to ensure that, okay, people call themselves vessels, okay, oh, I'm the vessel of God, I'm a vessel, not understanding how that implies liability, meaning that you're responsible for whatever it is that you're a vessel for. You're responsible for that. If you're a vessel for God, then you're responsible to whatever duties and requirements that this God has for you. All right, I'm just saying hypothetically. Okay, Now, or just as an example, a lot of people who are into religion don't understand that aspect, and they live free range, because uh, the entity that they're claiming to be in affiliation with, uh, the God or whatever, the spiritual aspect of their belief and who they're accountable to, okay, is, not in writing. It's not binding, okay? It's private. So it's not binding in the public. In other words, if if they're claiming to be a Christian, then their Christianity, or uh, what I should say, them being compliant to whatever doctrinal standards of Christianity is not a public issue. It's private. It's not a public issue. The public has no forbearance or any type of right to interfere in that type of agreement or contract or whatever. So that is a good way of explaining or getting a full understanding of the difference between public and private. Because yes, a person may publicly profess Christianity, but we, the public, cannot hold them to any type of adherence to their own belief, even, or declaration of credence. And so, because that's a private matter, completely and totally a private matter, even if disclosed to the public that it exists, the enforcement of it is private, completely private. So, as with drafting in estate planning type documents, the courts do not, like wills and last will and testament and living wills and so forth, the court does not have jurisdiction over that. And so the best way to establish that the courts do not have public jurisdiction is to disclose that the private entity exists. And you would do so by drafting what's called a deed of trust or a certificate of trust or declaration of trust, okay? And those documents will not completely outline what provisions the trust the details of the provisions, but it will provide the court with sufficient information to understand and know that all of that is being handled by a fiduciary or executor of the trust or fiduciary of the estate. Okay. In summary of what I said, or to tie it all in, the most important thing is that in giving notice, that within itself put the brakes on jurisdictional oversight, puts the brakes on it. it does not allow them, when I say it puts the brakes on it, does not allow them jurisdiction. It cannot establish standing or jurisdiction to barge in and take over, which is what they normally do. They don't come into the house and take over, but they will seize or, what do you call that? Claim authority or jurisdiction over the financial estate when there's no will in place. It can be a handwritten will. It can be anything signed by the deceased. Also, I want to just touch on that aspect that any entity that's not a person is considered a deceased entity, or an entity that is not capable of doing anything. So it would have to have an authorized representative to actually do something. And so that's why you have always an implied understanding that there is a moving person behind this trust or entity, okay? An actual authorized representative of that trust or estate would be the fiduciary. A fiduciary is the person responsible for the estate. It's a person with authorized representative who holds the liability of handling that matter, okay? Now, they cannot waive their responsibility once they've been appointed as a trustee. However, it can be transferred or assigned. The responsibility can be transferred or assigned to a co-executor or a co-trustee or nominee or someone that has by way been assigned the responsibility. For example, if I was a trustee of an estate and I was required to purchase property on behalf of the estate as an investment tool, then if you hire a real estate lawyer or a real estate attorney, you then transfer the responsibility of that to those, persons. As with a CPA, a certified public accountant, they are then responsible for those finances that they have been given the responsibility of fiduciary duty to handle those finances. Now, that in the regard of dealing with the IRS, as far as taxation is concerned, your CPA is responsible for handling financial matters, but when it's all said and done, they are not responsible for your financial estate. As far as you paying taxes, because a CPA can't make you pay taxes. They can only tell you, okay, this is your financial situation, and do all the credits and all that, and file your taxes for you, if that's what you hire them to do. However, they're working with the information you're providing them, so they're not responsible for that. And so, if in fact, say the IRS finds some other assets or something that's taxable earned income or some such situation such as that, the CPS is not a CPA or certified public accountant is not directly responsible for that. You're only responsible for handling your financial affairs as much as you provide the information for them to calculate and such, and to make a professional determination of what they have calculated that you are responsible to pay. But the key words in the whole explanation of that is that you are responsible to pay. They are only responsible to handle the finances. You are responsible to pay. So, say for example, if you're wealthy and your CPA says, hey, you're making this kind of money, and so they may not suggest that you create some type of tax shelter, but they will notify you that, hey, you're open for being taxed for these assets or what have you, based upon taxation, tax law. So the individual is responsible for paying those taxes and or doing whatever they need to do to create or form entities that will help them in that situation as far as exemption or otherwise. Not avoiding taxes, but to position the estate so that it doesn't fall under the criteria of being taxed, whatever amount, that being taxed that amount. But essentially, everybody has to pay taxes. So where a lot of people go wrong is trying to be totally exempt from paying taxes, and that's how they fall in the in the bracket of being considered as avoiding taxes. What they call that? Tax evasion. Okay, evading taxes, not wanting to pay taxes, because the IRS will give you ample opportunity and tell you, hey, you need to do one of two things. You need to resubmit your tax statement or report of assets or what have you. You need to do your report, send an amendment to your report, or pay up. You have options. It can easily be amended, and certain provisions in tax law that will allow you a deferred payment or whatever, or less. And for nonprofit entities, the situation may be such that it's not taxable at all. It's tax exempt. But in any case, you will need to perform documentation that will allow them to recalculate to determine that. And so, if and when you make no effort to do that, and this is why they give you sufficient time, because if and when you make no efforts to do that, then it is considered neglect of your fiduciary duty, because they're operating under the assumption that everyone has an estate, and it has a fiduciary that's responsible for handling that estate. And if they don't, then it's safe for them to operate under the implications or the implied contract with public trust. And say people call it a straw man, that you have a unincorporated entity that is responsible and liable to the public for taxes. Okay. Liable to the public for taxes, in essence, means like people say, you owe Uncle Sam. Well, who is Uncle Sam? Well, Uncle Sam is the fictitious entity that assures that everyone is properly taken care of. It's the rich uncle. And the rich uncle stays rich because he has a continual flow of finances being reimbursed. I'll give you an example. The IRS is a public interest trust, and the IRS holds interest in public trust. And so when people receive their, what do you call those? Their income tax credits, that is finances. As if people are, I'm gonna get my income tax back, get a lump sum of my income tax come back. Well, the income tax is like paying interest on the finances that you have earned over a period of time. Okay, and they're utilizing the money. And so you earn interest on that money. And at the end of the year, they do a calculation to decide. That's what when you file your income taxes, it's a way of deciding how much should we give you back. Well, you owe us for this, and we owe you for that. You owe us for this, and we owe you for that. But at the end of the income tax statement, that last number determines who owes who. Do you owe us, or do we owe you? And so that's pretty much the breakdown of any tax financial report. It it's enough information to provide the IRS with numbers that they can calculate and decide what interest belongs to you and what portions are considered as public interests and so forth. So in that regard, if you were to take all the deductibles and credits that is allowable for you in your situation, circumstance, then whatever the balance is after that is the calculated amount that you say you pay to the IRS. So in order for you to calculate that you do not have, owe any monies to the pots and you're not operating in the negative, then you would have to reflect that on your financial statement by utilizing all of the credits available to you on the long form. If it shows that you need to deposit money, because that's all when you pay your taxes, that's all you're doing is depositing money into the systems. When you do that money paid for taxes is also can be credited right back to you. So all it is you make a deposit and then you receive a credit. And so, and with interest. And so people's like, oh, I pay taxes every year. Are not knowledgeable of understanding that at some point that financial contribution needs to be reimbursed within this. Because we have been taught the color of law that, oh, I have to pay taxes. Not say color of law because people believe that, and then you have people that don't believe they need to pay any taxes. Well, that wouldn't be fair to the public because we all putting in the pot. Okay, and that's the reason why the IRS can give leave to find you at fault of not of neglecting your responsibility to the public. You have public roadways, public highways, public, and a lot of public usage to infrastructure and so forth that allows you freedom to operate in exchange, in commerce, and say for that reason, a lot of people are. If you put it that way, they're not interested in contributing to that. They feel like I don't have no money to pay for no street, But if it's just put in a one pot, or I don't have money to pay for everybody's insurance. Well, if it's put in place, all the monies are placed in one pot, then everybody is responsible for something. And there's some irresponsible people who don't understand that everybody is responsible for some part of that system for it to even be in place for your benefit, even if you don't utilize Social Security benefits. It's there and it's made available on reserve for you. And so some people they opt out of receiving certain benefits because they believe that they don't qualify, or they've been told that they don't qualify, and so they concede to being denied the benefit. But the benefit is supposed to be a public trust available to everyone after after that account has matured. The account was created by your certificate of birth. The trust was created by your social security number. Account. Your trust was created, but the financial aspect of that trust is noted under, not your name, it's noted under a number because it is an account. Account number. It's not a person, it's a thing. And because it is a thing, a person would have to control that thing. It's a thing. It's an account. Okay. So just as they controlled it by creating the account, okay, no, you didn't opt in, but you also didn't opt out. You also did not opt out. Let's say I don't want to be involved in that. I don't want to have anything to do with that. Okay, so that's what I mean by implied contract. You didn't opt out, so you opt in automatically. Since your parents didn't have enough financial fortitude and understanding and comprehension of finance.
What is IRS Form 1099 OID
and they didn't have enough understanding of what was being created by the signing of the birth certificate, people opt out by lack of knowledge of the benefit of forming that type of bond instrument. Okay, so I did enough rambling on and explanation of what we're getting into. I accidentally tapped on that video.
What is IRS Form 1099 OID?
We're not going to discuss that
what
because...
What is IRS Form 1099 OID and how does it impact your tax returns? Today we're diving into the
that I do not want to play that video about the original issue, although it is relative to this discussion, because this particular video, as with many videos about tax forms, they're very unknowledgeable about the alternate uses of forms, and they only have a one-track mind of what their understanding is concerning these forms. And so that she's addressing an original issue discount, but in the regard of a financial institution, and not without having the understanding or knowledge that every estate is considered a financial institution. And so those forms can be used for other purposes. Back to what we're discussing in this broadcast, most specifically, is creating trust instruments, which are original. You can draft original issues, but I think it's very important to understand that original issues have already been drafted on your behalf. So understanding what they are and how they work is very vital to understanding the elements of an original issue and what the criteria is and how it works and how it matures and so forth, and that it doesn't need to have a maturity date and so forth to be considered as a financial instrument. Uh, and so that's why, uh, and it needs to have documentation uh, drafted in that manner to say when the instrument will mature and so forth, and its value and interest and so forth. And so documents have already been drafted on behalf of our government. I mean, on behalf of the constituents of our government, not on behalf of the government, on behalf of constituents. The constituents are the people. And so since documents have already been drafted on your behalf, these are the results of the implementation of those documents. And so learning that first and foremost would definitely help people who are trying to get an understanding of how to draft their own documents, I would assume, because most people are not familiar with how trust work, and they have a tendency of trying to access trust directly instead of understanding that all trust must be dealt with, whether private or public. You need some documentation of any type of financial instrumentation. In other words, ain't no such thing as you have a trust and all the money is being transferred and moved and purchases and this and that being made and, access to some type of funds under the table. It's no such thing. Those funds can be accessed and moved and done privately, of course. When you have your own bank account, don't nobody know what's going on in your bank account, okay? But that information can be accessed at any time. That's how people's assets are frozen and so forth, wages garnished and so forth. And or, for an example of the IRS, they'll place a lien on you as a person, put you in prison, because you as a person have value. And so if you have a debt or obligation, that it can be considered as a debt that they need to place a lien or bond on your head, then that's what they do. That's how they acquire what I mean, a lien, debt, obligation, liability, whatever you want to call it. Say, for example, you harm someone physically, and they may say, oh, well, if you harm someone physically, money is not acceptable. You will need to pay by servitude, going to jail, and they they put you in jail and stuff. You do your time in jail with the loss of your right to public public, the use of the public. In other words, you was out in the public, and not considering that was an entity shared by all, and so they took that right from you and placed you in incarceration uh, with restricted access to the public. And they restrict your access to the public through probation, parole, and all that type of stuff. That's a restriction. That means they have legally gone through the procedure to deem you incompetent to handle yourself in the public, and that you have caused some type of liability in the public, a danger to the public. In which the law allows them to incarcerate you and keep you and restrict your access to the public. That's the most simplest way of understanding what public trust is, so that people understand that where the line is drawn between the private and the public. You may privately, in private, harm someone, but they may bring that offense to the public to be judged and say, hey, say for example, if you're a spouse in a marriage that is private, however, if you have, what do you call that? Marriage license, that is a public entity that the courts recognize. Okay? However, you can have like an inner, you know how people have problems inside the corporation, okay? Got somebody inside the corporation disgruntled, they file a complaint within the corporation, all right? And so with a marriage where you have domestic violence, you have an entity that is you don't have a mediating party. And so, for example, if your spouse was to take you into court, they are utilizing the public as a mediating factor, all right? And so the use of public services in that regard is public. It's no longer private. Now, how people say, don't put your business in the street, okay? So when you have an issue like that, it causes you to have to put your business in the streets. If you have private trust, and there's a difference between revocable and irrevocable. We're not going to go in detail as to the differences between the two, other than to say that definitely, if it has not been worded as such to be irrevocable, it defaults to a revocable position. So a marriage in itself is supposed to be a irrevocable contract, okay? And so if there's a breach of contract in that marriage, you know, the reasons people get divorced, and that's so for whatever reason, there's a breach of contract, that case is brought before the court because it's considered as a breach of contract. It's not, oh, my husband didn't You know, it's not personal. It's business. It's strictly business. That's why they require uh, for financial statements and so forth to be submitted in to documentation in these types of family law practice, because of the fact that no court procedures are about your feelings. No court process is about how you felt about something. Court processes are there and available because of the importance of equitable interest. Okay, in procuring interest, in procuring costs, procuring um, means to get money or get some type of financial value. Even a marriage certificate has a financial value because of the fact that when you're married, it places you in a different status. Your estate is handled in a different manner and cannot be handled uh, in the same manner as the person that's single. Okay, the parties, the marriage has power. The marriage itself, not the people in the marriage. The contract of the marriage has power. In other words, it places you in a different tax uh, requirements, okay? Because now you got a team of people in the entity of marriage, and that team, you have two people responsible for one act. In that regard, they share responsibility, they share liability, and they also share the benefits. In that regard, the two become one. Okay. Also, they can act separately. They have the benefit and the privilege of acting separately in some circumstances. Okay. In other words, they may decide, baby, I have a lot of health problems, and I may pass before you do. So instead of you having the hassle of trying to get my name off the account when I pass, we just gonna get an account in your name, and we'll both just access it on our, on their end. They order two cards, and it still has, say for example, if the husband is the one who has a deteriorating health, and they get the account in the wife's name only. Well, that husband still has legal right to that account, or whether it's expressed on the account or not. He would have to take some additional measures to access the account by authority, but by right, he automatically has the right to even pursue getting it by, a court order or whatever to access the spouse's financial assets. He has a right to pursue a mandate. Okay, if he's not married, he don't even have a right to pursue that. You can't just say, "Oh, you're supposed to have, give me half." What? Okay. Not only is the bank gonna look at him crazy, but the court's gonna look at him crazy and deny the request, because all persons who are not married do not hold that type of Right. They don't have the right. They don't have the right. They don't have anything with which they can uh, base their claim upon. Okay? They don't have no stake in the game. It's for people who want to be in relationships or uncommitted, but they want the benefit of the relationship. Where you can't in when you're dealing with taxation and other things like that, dealing with government entities and so forth and so on, you can't play them kind of silly games as far as not committing and receiving commitment kind of benefit. Uh, the crazy thing about it, I've seen people who were lawfully married, but they live in separate households. That's private. Even though people in the public and in the community knew that they lived in separate households, they also knew that they were legally married. And so there was no evidence to negate their union, uh, which lawfully allowed the spouse to access their benefits as a spouse once one of the spouses were deceased. Uh, Please understand, deceased does not always mean dead. Sometimes it means incapacitated. Sometimes people get hospitalized and they can't do anything to care for themselves anymore. And they may give over power of returning to someone. Now, like I said, in a marriage, that power of attorney is automatic. Automatic. In the event you are not legally married, then a power of attorney is suggested to be the best alternative in reaching that type of outcome. For example, if you didn't want to marry for some purpose, say, for example, in a will, your previous spouse wrote that if you were to marry, legally marry, then whatever finances they receive from you would be cut off. It would end, it would cease. A lot of people don't want to remarry after their spouse has passed for that reason. And so they may establish a relationship with someone that they love enough to make some provisions for them. That's equivalent to a marriage. Equivalent, but not technically. All right? So in that regard, they may give the spouse a power of attorney that will allow them the benefits of being able to handle financial affairs, and they can word that power of attorney in such a manner to allow them the freedoms of doing the same things that a spouse would legally and lawfully be allowed to do without a power of attorney. Now, I will say this: when that spouse is legally and lawfully married, but not living in that household, that spouse may even need a power of attorney. So it's important to understand and know that if and when there is no documentation of the will of the testator, it can be contested. Even a power of attorney can be contested. However, once it's been established the competence of the testator or the grantor of the power of attorney, that power of attorney stands and can be utilized in the manner in which the grantor, allowed, put provisions to the extent the provisions were made within that power of attorney. So you'll see people use the word power of attorney, but power of attorney is not a blanket form or blanket provision. Anytime there's a power of attorney being used, the next question is, what type of powers have you been granted? Okay, what is the extent of the powers that you have been granted? Some people have very temporary and specific powers being granted. Okay, I grant you the power just to sign this document on the purchase of this home or the purchase of this vehicle. Only one specific thing was to access my medical documents. Only allow you to access and review those documents. I don't allow you to do anything with it. I'm only allowing you to look at it, and so forth and so on. There's stipulations that can be placed and specialized powers being given. And so in that regard, when people just say power of attorney, it kind of annoys me because all power of attorneys are not created equal. Now, I use the word power of attorney as an example of transfer of rights or responsibilities. That's what a power of attorney can and does do. It gives somebody the right to do something. Now in that general nature of a power of attorney remains, prevalent amongst all powers of attorney. That's what a power of attorney is. It allows that person to act on your behalf in that manner. Even in a court matter, if it becomes a court issue, the court will then say, this person has a lawful right to act on this matter or litigate this matter based upon the powers being granted in the power of attorney. And so they can't even litigate on your behalf based upon that power granted. Some people may even put terms in there, you can do this, but you can't litigate. We're allowing you access to my medical files, but you're not allowed to do anything with it. Means that, hey, this is as far as you go with this. And that's it. Say, for example, a power of attorney, a power of attorney that allows the management company to collect rents, owed, due, or whatever on property may not also simultaneously allow them to pursue any litigation based upon their authority to accept payments. So that agreement with that management company may not even have transferred the right to litigate. They may have to, okay, whenever people don't pay, forward that information over to the actual owner and let them pursue litigation, or perhaps they have some type of system set up where when they encounter a delinquent payment situation where they forward that over to a collection department or a collection agency or some type of foreclosure procedure company, which is a totally different company designed to litigate. Past management of the property and its financial affairs, they may be limited to just collecting money. And so, if they're limited to just being a person who collects the rents and deal with the maintenance and other issues on the property, then they would be instructed, more likely situation, they would be instructed to forward it in a delinquent payment issues to a collection type of entity that will send the proper notices so that they don't, I would say, try to strong arm a rented a tenant or something like that and place liability upon that company. They don't trust them to do that. They trust maybe some type of company that deals in collection, that is familiar with the procedures of giving proper notice and so forth and so on to get it to that process of litigation. Eviction, whatever eviction is definitely one of those types of businesses that, when people are renting or leasing, it's definitely one of those types of entities that may have more than one company handling the fiduciary duties of that company. And because the fiduciary duties fall upon anyone dealing with finances. So someone collecting the money would have some level of fiduciary duty, not to say skim off the money, charge people more rent, and say, for example, the landlord says, hey, I want $1,200 for a 2-bedroom, and I'm gonna give you 200 off the 1,200. And they've already been allotted their portions of commissions in that agreement, and they choose to try to skim more money and charge the tenant 14 or 15. And they're like brokering the unit. Well, they aren't licensed brokers. So in that, if they aren't licensed brokers, in that regard, they have violated their fiduciary duty to handle that matter in according to the terms of agreement. So there would be, I forgot what they call it. Not laundering, it's something else when you're stealing money off. And absorbing prices, adding more so that you can get that amount off the actual purchase price, or rental, or lease, or whatever. I remember back in the day when they used to have those apartment locators. A lot of times the apartment locators, they would tell you a different price, and they would get you a lease and everything. And you go into the office of the apartments to tell them you want to rent the unit. And they didn't already knew that the apartment locator lied to you about how much the unit actually costs. But they're like in cahoots, conspiring with them. They're like, okay, if you get this dummy to pay this amount, we'll go for it. We'll write up the contract for that amount and everything. Then give you your cut, because we only wanted $900, and you got them to pay $1,200, and then we'll give you your cut out of that. And so that's the way that they get paid, by seeing if you're willing to pay more than what the person that's renting the property or leasing the property is willing to take. And that is a broker. That is a broker. That's not a lease. Leasing, they call them leasing agents. Okay, the agents, which is another alias for broker. So pay attention to that as well when you see different names. This broadcast is about the significance and importance of understanding the written application of fiduciary duty, okay, or fiduciary responsibility. An agent has some level of fiduciary responsibility, but that is not openly disclosed by just stating that they are an agent. They're not saying what type of agent they are specifically. If they were to write authorized agents most specifically, then it can be understood by all that they're an authorized agent or party, a potential party in a litigation. They have the right to litigate. Okay. You can't be an agent and not have the right to litigate. That part. So that, just that word implies authority. So you're gonna have to put authorized agent. Some people will put acting agent. That right there tells you they may not even have the right to litigate. It's a 50-50 chance that they may or may not even hold the authorized the power of authority to act in a litigation. Because as I said before, the grantor has to expressly imply that if it's not already a generic uh, criteria. In other words, when you marry, on papers, they have certain rights that's embedded. It's nothing extra they have to do for that. All right. When you're an agent, you have rights and responsibilities that's automatically embedded. Okay. And so, as far as titles are concerned, uh, power of attorney. We already discussed that. And the range of power that could exist in a draft of a power of attorney. Because it's really important to understand that if your power of attorney has been drafted or any type of documentation authorizing power to do or power to act, the details, why they say the devil is in the details. Yes, sir, the devil is in the details because the lack of a clause, to me, can be detrimental to the power of the acting power, what they can and can't, what a person can and can't do, or placing limitations on that ability can be detrimental if it's not done. It can be detrimental if it's done and worded in such a way that's confusing to the court as to what power that person has to act. So it's very essential to have clauses in there that are clear and concise, but it is essential, most essential, to have some clauses. If the court doesn't even have a clause to discuss, I mean, how far could that discussion go? If there's a clause that is not easily interpreted, at least you have something there to be interpreted. Yeah, but give yourself a fighting chance to be for that for the details to be discussed, because you have something they can work with. If it's a very generic power of attorney, it's not going to have enough clauses that could cover circumstances that may arise related to whatever the power of attorney is being issued for. And when it comes to litigation, standing in court is extremely important to act on behalf of another. You need standing in court. And what I mean by having standing in court, or you need standing in court, what I mean is that you have to, if you're acting on behalf of another, you have to have some proof that you've been given the power to do so. Otherwise, you can't. You're not supposed to. It's not supposed to be allowed. You do see the courts acting in that manner on behalf of defendants in the criminal system quite often. However, the legality of that is sketchy. To say the very least, is very sketchy. It's being allowed, but not legal. So sketchy as it is, that's how what the truth of the matter is. Okay, what we're gonna be going over. Remove this. All right. this video of, let's see, K West Estates. And she is a follower of Patrick Devine. And I made some comments on the in the comment section relevant to the video footage prior to initiating this broadcast. I watched, as you can see where the red indicators are, I watched this video. And so what I'm going to do, I'm not going to force you all to rewatch, to watch the video, the entire video, but you can see the title of the video and so forth to look it up and watch it in full at your leisure. We're just going to be doing a discussion about the portions of the video that are relevant to the title and topic of this broadcast. And the title of her broadcast was Notice of this video is Notice of Foreclosure, and um, how it got to discussion about your name and all of that. I don't know how she ties it in, but what we're extracting from this is some thesis or theories that other people have concerning these matters, and just really trying to discuss different theories related to the topic, and also um, how people do it, see how other people do it, and discuss whether, not whether it's wrong or right, but to discuss what is the grounds upon which their understanding can be established as a fact or truth. Okay. Based upon what our knowledge is of contracts and so forth, and how documents can be drafted and perfected in law. Let's get it.
What if I told you that every time a bank declines a small business loan application, that could represent an opportunity for you to get paid? So give me. I had to pause for a second. Okay, so in parentheses, they have in the state or trust. If you are acting, I'm going to plug that in.
Hold on.
The sentence.
Let's go back, because she's been talking for quite some time in this broadcast, and so I don't want to kind of just throw you in halfway in the discussion about the parentheses. Let's get it from here.
Because for a mortgage or a car contract or whatever the case may be, the one thing that they all asked you for was some form of state ID. They wanted to see a driver's license, some form of government issued identification. And on all government issued identification, that name is written last name, first name, middle name. Go and look at your documents. And then at the bottom, your authorized representative's name is written, like in my case, okay? My offshore account is Wilson Christina Meredith. But when I signed, that authorized signatory, okay, signing on behalf of the taxpayer and the financial institution, the account and the financial institution was Christina M. Wilson. That is a different entity. That entity that signed that contract is not binding upon the person that signed it. When we sign it, we're binding them to the terms, not the other way around. On box number 1, the name is going to be written last name, first name, middle name. If you don't have a middle name, it's just going to be your last name and your first name. The identifying number in the instructions, okay? Please, for the sake of all things holy, so that y'all can stop cussing me out, please read the instructions, because I say this all the time. Do you know that, like, the reason there are so many different factions or churches, right, And you wonder, like, okay, how did we get Seventh-day Adventists and Baptists and Mormons and Jehovah's Witnesses? Like, how all of them are reading the Bible? How are they all coming to different conclusions about the interpretation of the Bible? And that's what it is. It is because they interpreted the instructions of the Bible differently. Okay, and so rather than this my channel or my business being somewhere that kind of tells you what it says, I tell you to read it for yourself, and you come and you tell me, do you agree with what this says?
Right.
Do you agree with my interpretation of it? And if you do not
There you
agree,
go.
this is how iron sharpens iron.
Right.
You come and you joust with me, you duel with me, okay? And you tell me this why I don't agree with you, okay? And make a better argument, or not argument like in a nasty way, but we are trying to get to the bottom, like which interpretation makes the most sense. And
Right.
debate is the best way to expose that, okay?
Which
But in the
interpretation should be
instructions,
established upon facts.
it says, for, where was I? I was talking about the identifying number, okay? Where is it? Okay. If you are acting for an individual debtor, or other persons whose assets are controlled, the identifying number is the Social Security number or individual taxpayer identification number. But if you are acting for a person other than an individual, and in 6306 they say, if you are acting for a person other than an individual and they have estate and they have trusts in parentheses, if you are acting for a person other than an individual, and in parentheses they have an estate and a trust. They do in the publication, the IRS publication. So they have an estate and a trust. Hold on, everyone. Sorry. Sorry about that. I had to pause for a second. Okay, so in parentheses they have an estate or trust. If you are acting, I'm going to plug that into the sentence so that you can, and y'all, please understand. Translation, okay? When reading these instructions, the best advice that I can give you, if you are reading instructions, okay, and let's say you come to a word that you don't understand, meaning that as you're reading, this word does not translate in your mind. Like, let's say if you're reading a sentence and the word deceiting pops up, okay? And if the word deceiting does not translate in your mind, you must stop. You get a dictionary and you look at the different similar terms for a deceit, and you'll find like a deceit can be a natural person or it can be an account, okay? So let's go with account because we know that decedents are corporate accounts. Instead of using the word deceitant, replace deceitant with a corporate account, and then you try to read the sentence again with the word, with the replacement of the similar term or word or whatever the case may be. You replace it and then you read it again, and this will help translation. You have to understand what it is you're reading. You can't just read it, and the reason that I'm reading it is because Christina told me to read it, but I don't understand what I'm reading for myself. You cannot approach this with that type of mindset. You must translate. Every word must translate in your mind. This is one of the reasons that Jesus' language, Aramaic, became obsolete. The reason that it became obsolete was because the money changers was changing the words little by little until now the people don't speak Aramaic no more. Now the money changers got the people speaking. I think it's like Arabic is the closest language to Aramaic, but it's not the same. Okay, there are some people that say that they can read Aramaic, but but others are saying that no, that language is really dead. It really is a dead language. So that's what happens, like with words and terms. Okay, like they use word male and female. Well, those are corporate terms. The actual word that we use is man and woman. Parent is a corporate term, but the actual terms that we use in the natural world, in the real world, is mother and father. Okay, so this is how languages become obsolete because people are not aware that slowly but surely they're changing our usage of certain words
Right.
and then assigning new definitions to them. So you have to become like you have to be aware of just about as many things you can become aware of. Okay, so back to the instructions. Okay, I am reading the section of the Form 56 instructions that talks about the identifying number. If you are acting for a person other than an individual, an estate, or trust, the identifying number is the employer identification number. The EIN is going to be that EIN number for that judge's courthouse. We don't know the judge's social security number or none of that, okay? We're going to enter that EIN number for that court. It is not even a real court. It's a private business center. Okay, that's somebody's private. That's a private place of business where a bunch of people go in there and call themselves judges in their legal name and pretend to have some type of damn authority over us. So,
my wife in the truck here in Collin County, Texas. 14 million views.
Now
as
she's
of
getting
this
off
morning.
into
Now, the comments are
opinion a
exactly what
little
you
too
think they
much.
are. So I let her take the truck to
that is what the identifying number is. The decedent's social security number is social security number with dashes. Okay? The judge's name. Now, for you, you individuals out there, you individual bankers out there, okay, that set up your own estate, private bank, and foreign grantor trust. Kudos to you because now you have been exposed to certain acronyms such as TTEE. You know that if you set up your foreign grantor trust, that the acronym TTEE is what you put on the end of a name to indicate that they are a trustee. The trustee is responsible for the taxes. They are liable for the taxes. Okay? Like for example, your deed of trust or your promissory note, whatever the negotiable instrument was, if this court is talking to you, they are in holdings, okay? They are in, remember I told you that a lot of these corporations are holdings companies. They are in holdings or they have received your assets. And since you don't know what's going on, okay, they're hoping that some negligence can take place and then they can get an easy victory. Now we know that you absolutely can sign this Form 56, binding them as a fiduciary. Now, that bond that we have, okay, because before, like, there have been a couple of people that came to me and asked me, like, how do I file a claim against a first bond, okay? I did not have a lot of advice on how to do that because I have not had to do that myself. So I'm going off of what I understand the instructions to be. However, I wholeheartedly believe now, and after reading that publication, I think it's 6306 of the IRS manual, that if you fill out this 56 and you're going to send a copy of the 56 to the insolvency, it's like the insolvency and quality office for the region of that taxpayer, which is that offshore account. Okay, and so since that account is offshore, I'm going to show it to you guys because I know sometimes talking about it, you don't know what I'm talking about or you don't understand what I'm talking about. But there is, and I think it's called AIQ, assurance, is it assurance, insolvency, and quality? It's some office where we have to file these 56s. Now for these 56s, you can fax this over to the AIQ office, okay, for that taxpayer, which is your last name, first name, middle name. Okay, so I was talking about the individuals that set up their own estate private bank and foreign grantor trust. You were exposed. The IRS told you this, that hey, if you appointed a trustee for your foreign grantor trust, hey, are you okay with, we're going to shorten TTEE or trustee to the acronym TTEE, but TTEE stands for trustee. And in the instructions, okay, you be specific on what type, who is fiduciary of what, because there is a such thing as a master fiduciary, a master trustee, okay? They are just, this judge is just a plain basic trustee. The reason that we need them to handle these assets is because like that deed of trust has to be brokered. There are CUSIP numbers that we don't understand these. We don't know how to broker these contracts and commodities, and we don't know the different brokerage codes that they're using. But that is that judge's job. Even the clerk, even a lot of these clerks are brokers. The county prosecutor is also a broker. Okay, and so when we're doing this 56, you also can do a 2848 and appoint that prosecutor, that county prosecutor. If that judge do anything other than what you told them to do, you stick that county prosecutor using that 2848. Read that 2848. That 2848 says a lot. It says, hey, what kind of duties do you want this attorney to have? I want them to be a whistleblower. I want them to fill out a 3949A, because like some of you guys were like me, like I filled out a bunch of 3949As and they are not going anywhere. And the reason being is because we are not identifying the correct individuals to pay the taxes that's owed to us for usage of our property. We haven't identified them yet. Is it wrong to make ourselves fiduciaries, like when we're doing a draw or bar? No, that's a different scenario. But when we're dealing with like I said, a foreclosure or repossession, no, start putting these 56s on them, because now you can, that freedom of information, that FOIA request, look at that 2848. You can make that attorney, tell that attorney, go give me that bond information for this judge who is going to be brokering the decedent's assets and forfeiting them over to the creditor or receiver. So I'm going to show you that your the title that you use when you sign the Form 56 is different from the title that you assign to the fiduciary, the judge. It's different. The judge is going to be the trustee, but you're the receiver. You're in receivership because they are in bankruptcy. Bankruptcy, they're all in bankruptcy. They're bankrupt. The moment that your money got deposited into the court, remember, a liability was also created. So let's say like my house, $150,000, okay? So whoever, if someone goes to deposit my deed of trust down with the court, okay, now the court is holding $150,000, but they are also holding another side of the balance sheet, which is the liability side, because it's reasonable to assume that this money is going to be withdrawn and this court will be liable for paying this $150,000 out to its beneficiaries or its rightful creditors or owners or whatever you want to call it. The money don't go to them, bottom line. That money comes to us, period.
I'm trying to pay off your loan. I'm calling you to let you know that we're gonna pay off every loan you have. Like,
okay, so on Section A, authority, I picked F, bankruptcy or assignment for the benefit of creditors, because we are assigning this judge who is bankrupt. Remember when I talked about in my last video that a reorganization is taking the assets out of these decedent accounts, okay? Taking them out of the mortmain accounts and reorganizing them and putting them into our custody and possession. That is what a reorganization is. And the United States, every corporation in the United States, in all 50 states, are in bankruptcy. All of them are. Every last one of them are in bankruptcy. Okay, under a Title 11 of the United States of the United States Code goes into detail, and I suggest that you read Title 11 of the Bankruptcy Code, where they go over everybody and the Emergency Banking Act. Y'all, listen when I tell you, the Emergency Banking Act talks about how the United States Department of the Treasury is also bankrupt. Every last one of these corporations are bankrupt. Even the treasuries that we think are real treasuries, these treasuries are de facto treasuries. The only real treasury in America is us. Period. There is no real treasury. I don't like Patrick was saying that, but that's like one of the things that I'm not so sure about. I'm not gonna say that I disagree with him because I ain't been in this game long enough to, to say definitively. But I'm starting to feel like I have had enough experience with the IRS to come to the conclusion that all of them are de facto, whether they are in Philadelphia or DC or in Puerto Rico. All of them are de facto treasury. And the only real treasury is us. And that's what we're trying to do. We're trying to reorganize all of this money that we have in these different offshore accounts and place them. They have to come back to the source. You've heard Patrick, all taxes have to come back to the source. We're trying to reorganize those assets back into our custody. And just like he said, okay, we need to supply a body to these fictional names to make them liable. When they hurt us, when they injure us, when they send in the sheriffs to our houses, when they send the tow trucks to snatch our cars at our driveway. And the whole time we thinking that they had to sign, so we have to send the 56 over to them for them to sign. And they don't. We sign it for them. And everything we sign, you can sign a satisfaction of mortgage on their behalf, you can sign a release a lien on their behalf. Because every situation that we're in is voluntary. It's all voluntary. So no, I know Patrick came back and said he think he made a mistake on those 56s when he said that we appoint the judges or the clerks or whoever, the sheriff as a fiduciary. He was not wrong. He just skipped over that section that says that, oh no, you absolutely, the person that signs this form can be a different entity from the named fiduciary because the fiduciary is treated as the taxpayer. And that local court is liable now. However much money that deed raised, that deed of trust, he or she now has to broker down that deed of trust. He or she now has to broker down that promissory note and pay you your money. And if they don't, your enforcement will be that 2848, the county prosecutor. They've been taking the county prosecutors on us. And the county prosecutors is not here for us. They're here for the corporations, for these judges. But now they best of friends. Go down to the court and look at how the county prosecutors, they best buddies. The fake judges, the de facto judges, the pseudo judges are friends with the county attorney. So they are in a conspiracy against us. But you can remove that with that 2848, and you don't need that attorney to sign. You sign on behalf of that attorney. And then we make them do their job. Now, authority, I said bankruptcy or assignment for the benefit of creditors, okay? In the instructions.
Ever rush to sue the other driver after a car accident?
There may be a much smarter way to get paid a much larger settlement without going to court or paying huge legal fees up front. If you've been in a car accident within the past year, even if you were only a...
For the benefit of creditors, okay? In the instructions, okay, they go over the different types. Okay, proceedings other than bankruptcy and assignment. Nope, that's not the one. That's something different. Proceedings. Okay, see how right here, I knew when I read this, proceedings other than bankruptcy and assignments for the benefit of creditors. This is a different, let's see, this is fiduciary and aid of foreclosure. Oh, okay. A fiduciary who is appointed or authorized to act as a receiver in a receivership proceeding or similar fiduciary. Include a fiduciary in aid of foreclosure. Or now, when you hear the word foreclosure, okay, the word is, oh, we're closing out this account, it's foreclosure. That's really what they are saying. But of course, since they put a more, F-O-R-E, and they spelled it a little bit differently, okay, some of these words are, like phonetically, you can hear exactly what's being said. Oh, this is foreclosure. But when you look at the word, it says something different, and then when you go read the definition, it's like, oh, foreclosure, somebody come and take your house because you ain't pay your bills, okay, and that stokes fear. That scares you, that makes you scared. An assignee for the benefit of creditors must file Form 56 on or within 10 days of date of appointment with the advisory group manager. That, I believe, was it the AIQ? Okay, so their name is the advisory group manager, and let me think. There is like a whole sheet with all of their numbers for different states, but for these offshore accounts, these 56s must go to the advisory, let me see, what does it say? Advisory group manager for foreign accounts or offshore accounts, whichever one it says, outside of the United States, pretty much. Service activated process. Oh. The receiver or assignee may also file a separate Form 56 with the service center where the person for whom the fiduciary is acting is required to file a tax return to provide the notice required by Section 6903. Okay, so for this kind of changed my mind a little bit. Proceedings other than bankruptcy and assignments for the benefit of creditors, because this one specifically talks about foreclosure, and of course you want to aid them in the foreclosure. When they talk about foreclosure, okay, the fraud is using the deed of trust to claim ownership of your physical house. Like, that's a scam, okay? The deed of trust is something totally is separate from your house. It has nothing to do with your house, okay? But of course, because we think that the terms in the contract is binding upon us in our minds, we think something different from what the actual case is, and whatever, we act based on what we think or believe. I'm going to dig some more into this right here for people that are going through foreclosure, because we can use other, see where other and describe, where it says other on the form. Let me see. If other describe, and where it says describe, you're going to enter proceedings other than bankruptcy and assignments for the benefit of creditors. Okay? Because this actually covers foreclosure. However, there is another assignment for the benefit of creditors where, So this is bankruptcy or, it says bankruptcy or assignment for the benefit of creditors. So it's either or. If you're a bankruptcy trustee or an assignee for the benefit of creditors, check the box on line 11. Enter the date assets were assigned to you on line 2B. And so the date the assets were assigned to that judge would be the date whoever that plaintiff is, it would be the date that they went and filed the case against you, because what happened is that they entered that deed of trust or that purchase agreement or both. They entered that, they deposited that with the judge as evidence of ownership that they own your house. Okay, and so that would be the date that the assets were assigned to, that they became a trustee the moment that they accepted your deed of trust.
John, how are people paying as low as $39 a month when I'm paying $400?
Because $400 is the rate for people who don't know $39 exists. I'm telling you, it's real. They just found a tool that skips the nonsense and shows direct comparisons so you can find your best rate. I was at $390 for 3 years. You were just getting the rate for people who don't check. Tap below. Enter your year, make, model. The AI pulls the best rates in your zip right now and shows you the real number. Seriously, it's 100% free to check. I shared it with people I know could use the help.
Hidden injuries could make your car accident worth a six-figure check. No, seriously, I skipped the ER after my accident, but my case ended up settling for $100,000. I really thought I was fine until about 4 days after my accident. My neck started tweaking, back pain started kicking in out of nowhere, headaches showed up, and next thing I knew, I was missing work, struggling to sit through a full day, and realizing what had seemed like something small at the scene had turned into something I couldn't ignore. What I didn't know then is that these are what they call hidden injuries. Whiplash, soft tissue damage, delayed concussion symptoms, nerve issues, the kind of pain that doesn't show up until days or even weeks after the crash. These are real injuries with real settlement value. They count, but there's a catch. They only count if you actually know how to claim them properly. And most accident victims have no idea. Here's where everything almost went wrong for me. I almost didn't do anything about it because I hadn't gone to the hospital the day of my accident. In my head, that meant my case probably wasn't worth pursuing. If I had really been hurt, I would have gone to the ER, right? At least that's what I told myself. That belief is what insurance companies profit billions of dollars off of every single year. They count on accident victims like me thinking, I didn't go to the ER, so I must not be hurt that bad. So I should just take whatever insurance offers. Insurance came at me with $5,100 and tried to wrap the whole thing up fast. I hadn't been to the hospital, my car wasn't totaled, and as far as they were concerned, my claim was already as good as closed. I was tired, I was in pain, and I was about to sign. Then my buddy told me about the Accident Compensation Service. It's a service that helps accident victims claim the maximum amount their case may actually be worth, including for the hidden injuries, the delayed symptoms, the missed work, all the stuff insurance pretends doesn't count. No suing the other driver, no courtroom, no upfront legal fees, no dealing with insurance directly. All I did was pull up their qualification tool, answered a few quick questions about my accident. Less than 30 seconds. The screen told me I qualified, and that's when everything changed for me. Once I qualified, a dedicated accident specialist took the entire case off my hands. Zero upfront costs, no insurance calls, no paperwork, no courtroom. They handled every bit of the heavy lifting while I focused on actually getting better and simply waited for my check. 12 weeks later, $100,000 was sitting in my bank account from an accident where I never rode in an ambulance, never went to the ER, and where insurance had me convinced was worth $5,100. Here's how you check if your accident may qualify too. Click the link, answer a few quick questions about your accident, and the tool tells you on the spot whether you qualify. Less than 30 seconds. Cost you nothing. If you qualify, an accident specialist could handle every call, every form, every negotiation, while you do nothing but wait for your settlement you may be owed. If you don't qualify, at least you will know. But if you do qualify, there could be a huge check with your name on it waiting for you. And the whole thing is $0 out of pocket. You don't pay a cent unless the service actually wins you money. Doesn't matter if your accident was 2 weeks ago or 11 months ago. If you walked away feeling fine, if your pain showed up later, if you didn't go to the ER, if your car wasn't totaled, you might be exactly who this service was built for. These are the cases insurance hopes you never look into. Just think about it for a second. What could $50,000 change for you right now? $100,000? $200,000? Medical bills cleared, rent covered, credit cards at zero, real breathing room, instead of the pain and stress you've been carrying since the accident. But these cases come with hard deadlines. Insurance companies know those deadlines, and they'll stall and delay your file on purpose because every day that passes is a day closer to your window closing. Once it closes, they owe you nothing. You can believe me or not, but it's free to check. It only takes 30 seconds. That 30 seconds turned into $100,000 for me. I came one click away from signing that $5,100 check because I assumed skipping the ER meant my case wasn't worth pursuing. That assumption would have cost me almost $95,000. Click the link below, answer the few quick questions, and find out in under a minute whether you qualify. It's free, it's fast, and if you qualify, this service could help you get paid what your case may actually be worth. Click below and check right now because you might be owed a huge check without even realizing it.
Okay, but I want to read some more into this option as well, where we can select other and enter proceedings other than bankruptcy. See, I don't want to do other than bankruptcy. I'll have to think about it. I have to think about it. I would, because technically we're not bankrupt. I'm gonna think it over. And I want y'all to read 6903. And I want you to read these instructions also and tell me what you think. Give me feedback. But I think we should stay in the parameters of bankruptcy, honestly. So line 11, not line 11, that's 1F is the option that I'm with. You can do this for a sheriff. If a sheriff is at your door, oh, Sheriff Jesse L. Harvey, okay? Immediately put a 56 on that sheriff. That sheriff is acting as a debt collector. Somebody come and arrest your husband or arrest your wife. Immediately put a form 56 on that police officer and the 56F on the police department because now they owe you money. They're fiduciaries now. They have taken your body as deposit. They're holding your body as collateral. Okay. Back to, okay, so for 2B, if box 1C, E, or 1F, or 1G is checked into the date of appointment, and remember, I said the date you received the case, but you can enter the date that whoever the plaintiff is, the date that they deposited your asset with the court. The nature of liability and tax notices, okay, they owe you income and estate taxes. And honestly, I kind of feel like they owe employment and excise. I take all of them, to be honest. I take every last, except generations giving transfer and gift. Federal tax form number, check all that apply. Let's do the 1041, and all applicable 1099s. More than likely, the primary form that judge is going to use is a 1099B because he has to broker and barter that contract, and we should receive a 1099B showing the settlement of the funds. So I don't know if they're going to the court can issue a check. I would assume that they have the ability to, or if they're just going to give a 1099B, and then you can use that 1099B to claim whatever that amount is on that 1099B that the judge wrote.
Who could be approved for $39 per month, full coverage auto insurance. The only catch is that you need to have 0 DUIs in the last 5 years. Drivers with 0 DUIs in the last 5 years could qualify for rates starting at $39 per month for the same coverage. So please, click the link below to get a new rate today. It will only take 5 minutes. Once again, if you have 0 DUIs in the last 5 years, click the link below.
Right now, he's learning tricks in his new kitchen, which is a big upgrade. But before that, we checked his approval odds on Credit Karma and finally renovated with a lower APR personal loan. Oh yeah, now he's cooking. What will you get more confidence to do? Download the app.
Okay, so you see how up here, what I was saying to you guys, the judge's name, comma, TTEE, because that judge is acting as a trustee. Okay? We appoint the judge as a trustee, but we are down here as a receiver. Okay? Because we're in receivership for the assets that this trustee brokers. We're receiving because this is our person. This person belongs to us and you owe us rent for usage of that property. You sign as a receiver. Now, the 56F, let's see. Okay, so the 56F also has to go with the 56. The name of the court, okay? The court EIN number. The address, city, state. The court is bankrupt. It is insolvent. Okay? It is what makes a corporation bankrupt, okay? Like to try to help you guys with understanding. The reason that the court is bankrupt is because its liability likely exceeds its assets. Meaning that just about everything that's deposited with the court is someone else's, their assets, is someone else's time and labor or money, whatever you want to call it, has been deposited with the court. But whatever the value of that asset is, it is offset by a liability. So if a person comes in and deposits let's say a deed of trust, okay, valued at $100,000, automatically a liability of a negative $100,000 is created, meaning that the bankruptcy court has $0. It has $0. And the only money that the court, like the judges themselves, make is maybe the $50 or $100, however much they charge to hear a case. That's the only money that they're supposed to make. They're supposed to be working for fees, but they big time it because now, they selling houses for people. So that's way more lucrative, okay? Finessing people and scamming people is much more lucrative than working for, these little petty $50 or $100 they might make from, people filing small claims in their courts. They'll get richer faster by stealing your house. The name of the court goes here. Employer identification number, okay? The fiduciary's name, I will put the estate. The estate is overseeing like that. When we opened our estate, okay, that estate was open for asset exchange for banking purposes to pick up the assets that we left behind. Was that deed of trust not an asset that we left behind? The appropriate entity, in my opinion, you can also use, if you want to use your private bank, use your private bank. But in this instance, like if you're dealing with a foreclosure, I would use the estate. The fiduciary's name, the name of your estate goes here. Contact person, Christina, okay? Address of fiduciary, into your home address or P.O. box, whichever address you use on that CP 575 notice that you got back from the IRS showing the creation of your estate. You use that exact same address. Check the applicable box if the fiduciary is a receiver. is a receiver. Let's see. I don't fill out 16, 18. I don't fill out those boxes. I've always left those blank. Authority, appointment of receiver. Okay, appointment of receiver. Tax notices, employment excise, financial institution listed, indicate those recommendations, the type of thing. Okay, so like some people have, when did you first get your mortgage? What year? So you write TY, which is an acronym for tax year, and then you write all the years that that mortgage contract you got to be paid for. They owe taxes for all those years. When I say they, I'm talking about the judge owes taxes for all those years. And you put that down on that 56F. Be sure to do, let me be sure, because some of you guys like ask me the question, like how many 56s do I need to do? You want a 56 for any entity that you're acting on behalf of, okay? In this instance, we are not acting, we are making them perform. We're making them act as the trustee, and we're signing as a receiver. We're the receiver acting on behalf of the estate.
Snap a photo, list your item. Easy. Once it sells, the buyer covers shipping. And with zero seller fees, you keep every dollar you earn. Less clutter in your home, more money in your pocket. With millions of users and low cost for your buyers, it's easy to start selling and earning. Start selling on Vinted today.
Sometimes life can be a little messy, but with next-gen Novella Performance Fabric and Ashley, we've got your whole home covered, so you can get back to what you love, messes and all.
So the name on this 56 needs to be the name, like how it is written, how is your executor's name written. You're not going to call it an executor, but the estate is in receivership. And the executor is the person. The person, it is the individual to receive the asset. It's going to come to the estate, and then once it comes to the estate, the executor is going to disperse it to the beneficiary, which is you. These are your persons. This is what Patrick meant when he said you send your persons to do your dirty work. Okay, so this video is getting up to an hour long. Oh, one other thing, like I said, for any evictions, unlawful detainers, enter that court information on down here where it says part 3. It's real easy. You don't need me to hold your hand through every step of the way. Y'all got this. Some of y'all are just like, you're so panicked and you think you need to run something by me. No, you're an adult. You're capable of making good choices and decisions. Read it. Read it. What does it say? What does it ask me for? And make a decision. Okay, so enter the name of the court. What date did they say the proceedings were going to start? The address of the court, the case number. Okay, enter all the information down here. Now let me see, there is a section for, what did they call it? They called it the advisory group manager. Let's see. Okay, so here it is. This is the phone number for the advisory consolidated. Let me make sure. Okay, yes, collection advisory office. Let's see. Okay, so you see how they have the different states? The the 56 and the 56F should go here. Okay, and it says number 7. So we scroll down and we find number 7, and this is where it goes. Oh, they got the nerve. Plantation, Florida. That's what it feels like, a plantation. Okay, so this is where the 56 and the 56F would go. Okay, for international food, Puerto Rico. Remember, because that last name, that name on the driver's license, that name on the passport, that name, look at your DD24, look at any identification you've ever received, that name is written where your last name is first, and then they put your first name in the middle, and then they put your middle name last. Okay, those are offshore accounts or mortgage accounts that Patrick was talking about. Okay, so y'all saw how I got to the collection advisory office's contact information. I wonder where I got AIQ was in my head. Assurance, Insolvency, and Quality Office. I don't know why that name, or some similar names, like, that name's like stuck in my mind. Like, I've seen that, those acronyms somewhere. Maybe I'm mixing, I don't know. I'm tired. I can just be off in what I'm thinking. Okay. Advisory consolidated receipts. Purchase money. Oh, hold on, wait a minute. Estate tax advisory. Questions about federal estate tax liens. Deceased person. IRS forms or additional information. Centralized lien operation. And that's what Patrick kept saying, that estate creates a lien on any asset issued by the SSN or public bank. He said that the moment that we create an estate, that estate creates a lien on all of our property, borrowing to purchase property when taxes are owed.
The Millers love the sweet sound of earning and saving money on vintage, with 0 selling fees and free shipping on all items. Don't wear it, sell it.
Certificate of, oh, somebody laughed at me and said, oh, are you making a fake certificate of discharge? No. If a bankrupt corporation can make certificates of discharge, and we know without a shadow of a doubt that we can sign on behalf of a corporation, we can bind them to the terms of whatever is stated in our certificate. The IRS can create a certificate of discharge, we can too. Okay, so like, I'm starting to take y'all advice. I'm just going to kind of drown out the haters and the naysayers. Because really what's going on, what y'all don't get to see is that these people talk all this smack, all this stuff behind the scenes. They're actually taking my suggestions behind the scenes, but publicly and in the comments, they talking smack. And it's just annoying. Okay? It's just annoying. We're all here for a common cause, a common reason, and that's to gain control over our accounts. So that's pretty much all I got for you guys. This video is over an hour, which is longer than what I wanted it, but I had to share. I had to share that with you guys. I think that this is going to be I hate to say it, but a quick remedy. I hate to say quick remedies, but no, this 56 you can sign this 56 and that 56 and get that into those advisory offices as quickly as possible. And you let that judge know that, hey, you've been assigned as a trustee, okay, to broker that deed of trust that was deposited with your financial institution. You now have an obligation, okay, and you do that 2848, and you appoint that district attorney, okay, and on the 2848, what do you want this attorney to do? Oh, I want them to do a FOIA request for me, okay? You tell that attorney to go get that judge's bond, because if you do something I don't like, okay, and you can't instruct them, give you, the 2848, read it. It tells you like what powers do you want to give this attorney. I wanted to have the authority to take this judge's bond into bankruptcy and liquidate it and forfeit the proceeds to me for harm. If that judge harms you, if they don't broker down that contract and forfeit those actions over to you.
I can cool out for a minute.
All right.
Thank you for joining me.